Hello, I am Professor Emeritus Harry Flechtner from the University of Pittsburgh School of Law. And in this video, I'm going to talk a little bit about the substantive issues in the 27th Moot problem. Um, it is not going to be a deep delving into these issues. That is more up to you. And you've written both of the memoranda already. So you probably have thought of many, if not most, if perhaps all of the things I'm about to say, but maybe I can suggest a few ideas or at least give you comfort that you are approaching things in a way that also is the way I see it. Let's talk about the substantive issues, which are identified in procedural order number 1 in the problem. First substantive issue is, has respondent breached the contract by delivering turbines which are non-conforming in the sense of Article 35 CISG? There is a version of that issue which is found in the analysis of the problem for the use of arbitrators. And that analysis states it as follows: whether the mere threat that the turbines are not of the expected quality may render them non-conforming pursuant to Article 35 CISG in light of the special circumstances of the case, in particular the nature of the goods and possible consequences. That's an interesting, different approach, you might say, at least a more specific kind of approach to the issue. Let me say a word about the analysis of the problem for the use of arbitrators. It is an important document. It is not always proven to be always the way things turn out after all the pre-moots and everything that people massage the issues, and sometimes the actual issues that tend to be important in the moot are a little bit different from those that are given in this analysis of the problem. But it is an important document, and there are many arbitrators who will rely primarily, sometimes I think even exclusively, on that analysis. So it is certainly worth paying attention to, particularly in this case where that analysis at several points cites the Krill-Mistelis-Paralis commentary, the second edition, which is the latest, on the CISG for some matters. And given that Professor Krill is responsible for the problem, I think it's certainly worth following up those references. The second substantive issue identified in procedural order 1 is, in case of a breach of contract, is claimant entitled to request the delivery of replacement turbines? And the version of that issue that appears in the analysis of the problem for the use of arbitrators is this: whether the special circumstances of the case justify a request for replacement of the turbines even before the nonconformity has been established, has been determined with certainty. Well, let's talk about the first substantive issue first. That is, has respondent breached the contract by delivering non-conforming turbines, non-conforming in the sense of Article 35 CISG. I have set out Article 35 here. You're probably familiar with it already, but I'll just highlight a couple of the matters that are likely to be important aspects of Article 35. There's Article 35.1. The seller must deliver goods which are of the quantity, quality, and description required by the contract. A contractual obligation, as opposed to an obligation imposed by law, or indirectly, I suppose. Affirmative obligations created by the contract, and then Article 35.2, except where the parties have agreed otherwise, the goods do not conform with the contract unless they are fit for the purposes for which goods of the same description would ordinarily be used, fitness for ordinary use, and B, are fit for any particular purpose expressly or impliedly made known to the seller at the time of the conclusion of the contract, except where the circumstances show that the buyer did not rely or that it was unreasonable for him to rely on the seller's skill and judgment. So fitness for a particular purpose. Notice the difference. Ordinary purpose versus particular purpose. But also notice how these obligations arise. Under Article 35.1, you must find something in the contract, in the agreement of the parties to support the obligation. But under Article 35.2, silence, as long as the requirements for the obligation are met, gives rise to the obligation, but the parties can affirmatively agree otherwise. So Article 35.1, the contract creates the obligation. Under Article 35.2, the contract, in a sense, can take away the obligations. So, let me say a little bit about a breach by nonconformity in general. Goods are nonconforming. To prove that goods are nonconforming, there must be two things that are proven. One, that there is an obligation. There probably are many obligations in most contracts, and an obligation of quality of the goods or quantity, but quality is what we're interested in, that there is an obligation that arises with the contract, either one of those Article 35.1 obligations or those Article 35.2 obligations, and that the obligation that you're talking about has been breached, has not been met. The goods were not of proper quantity under those obligations. So you got to prove the obligation and then prove it was breached. It's not enough to prove there was an obligation if you don't prove that it was breached, and it's not enough to prove that there's something that is wrong with the goods unless that also breaches an obligation that arose under the contract. So let's talk about Article 35.1. So-called express or perhaps affirmative quality obligations are better to talk about that. Is there something here that suggests that the goods are or might have been non-conforming to something that was expressed in the contract? Well, I think you should look at that question rather carefully. There were various quality obligations that were affirmatively expressed in the contract. You might remember Article 11, the so-called informality principle of the CISG, which says that subject to some exceptions, a contract need not be in writing in order to be enforceable under the CISG, which suggests that absent anything else, you can look beyond the written contract to discover obligations, including obligations of quality. But in this case, that is limited. That principle, the informality principle, is certainly limited by Article 22.2 of the contract, which says this document contains the entire agreement between the parties. Now, this is a clause that would invoke under common law principles, U.S. common law principles, and probably other common law principles, the so-called parole evidence rule, which is highly developed in common law rules and confusingly developed, I must say. The parole evidence rule, which is triggered by this language, says basically that if a document, if a written version of the contract is intended by the parties to be their final version of their agreement, and perhaps their complete and final version of their agreement, then you can't prove things, you can't prove alleged agreements that are not found in the written document if you're trying to prove that during the negotiations, we agreed to this and we agreed to that, but if it doesn't show up in the final document, well, your proof is irrelevant because the parties intended to discharge any such obligation by not including it in their agreement. That's kind of the idea behind declaring this contract contains the entire agreement between the parties. So if you try to prove anything else happened during negotiations that doesn't show up in the agreement, who cares? We didn't want that to be part of our agreement in the end. So that certainly suggests that you're going to have to find something in the written contract itself, subject to something I'm going to talk about right now, in the written contract itself, we don't have the entire written contract, but you're going to have to find something in there that creates the obligation that you want to allege was breached in order to prove a nonconformity. The merger clause and the parole evidence rule in the common law view, and I think this is probably the way it would also be interpreted generally, looks backward from the time that the written contract was entered into, but not forward. That is, it says you can't prove stuff that happened before the written contract entered into force between the parties. You can't prove alleged agreements that are not found in that written contract if they are alleged to have arisen before the parties entered into the written contract. But they can always modify their agreement later. That is not affected by the merger clause. They can add things later. If you wanted to prevent subsequent agreements that are not in writing to be binding on the parties, or to be, excuse me, not to be binding on the parties, you would need something like a so-called no oral modification clause, NOM clause, as they are sometimes called, which we do not have here. It doesn't say that all modifications must be in writing, and those clauses are pretty tricky to deal with anyways. So in this case, we're going to, the effect of the clause would probably be limited to preventing proof of alleged agreements or obligations, not evidenced by the written contract that were allegedly agreed to before the written contract was entered into. Let's talk about Article 35.2, possibility of implied obligations. Are there one or more of the implied obligations in Article 35.2 that might have been breached? And there are a couple that seem to come up. Is it a possibility that these goods were not fit for their ordinary use? What is their ordinary use? It's defined by their contract description, it turns out. So ordinary use for the kinds of use that is described in the contract. Or as an alternative, are they not fit for a particular purpose if the requirements of Article 35.2b were met? Remember what those requirements are. The Article 35.2a ordinary use requirements arises in every contract for sale unless it is affirmatively eliminated by the agreement. The Article 35.2b, fitness for particular purpose, however, only arises if certain, not in every contract for sale, but only if certain further requirements are met. It must not only be a contract for sale, but the particular purpose must have expressly or impliedly been made known to the seller at the time of the conclusion of the contract. And then there is the possibility of that any reliance on the seller's skill and judgment to produce or select goods suitable for that use was not reasonable. But only if you have a contract for sale where the buyer did not make known any particular purpose to the seller before the conclusion of the contract, the Article 35.2b obligation will not arise. And here's an interesting question. Remember Article 22.2. This document contains the entire agreement between the parties. Well, nothing that I have seen in the document, we haven't seen the entire written contract, says that the seller must deliver goods fit for the ordinary purposes, or the seller must deliver goods fit for a particular purpose. So can you argue that Article 22.2, the entire agreement clause, also constitutes a so-called agreement otherwise, eliminating the implied obligations, the obligations that arise normally by silence in under Article 35.2. Remember, Article 35.2 says, except where the parties have agreed otherwise. Is Article 22 of the 22.2 of the contract an agreement otherwise? Certainly not a very direct or clear one, but a possibility, I suppose. Now, assuming you have identified obligations that might have been breached, and that's probably the easier part of this problem, well, how does that affect? Well, the respondent frames issue 1 as a burden of proof issue in its answer found in the record, page 28 in paragraph 15. Here's what respondent's answer says. It's request for arbitration, I should say. First, the turbines are conforming to the contract. Claimant who bears the burden of proof has not proven that the turbines are affected by corrosion or that there is an extraordinary amount of cavitation. The mere fact that it cannot be excluded that the turbines may have been produced from a charge of steel that has not been properly examined and is not in line with the required specifications does not render the turbines non-conforming. The remote possibility of a defect is something completely different from a defect. Now, one interesting thing about this is that it comes close almost to being an admission that, yeah, if defective steel was used, there is a breach of contract, and that could ease the stuff we've just been talking about in terms of proving an obligation that may have been breached. But of course, the issue that claimant brings up is, look, claimant has to prove that the goods were defective, and they can't do it because of the hack and the improper record keeping and stuff like that. They can't do it. This, of course, raises an interesting issue. Let's talk about burden of proof under the CISG. What law governs breach? Who bears the burden of proof under the CISG? Well, there's almost universal consensus that that issue is, in fact, governed by the CISG. I am one of the very few voices out there who disagrees with that, but the vast consensus is that burden of proof is governed by the CISG. There is certainly one provision that seems to allocate burden of proof expressly, and that is Article 79. It requires proof of the requirements of that provision by the party who is claiming who's claiming an exemption from liability for not performing under that provision. And based upon that, the theory is that that's a general principle establishing the basic burden of proof rule under the CISG of the so-called rule exception principle. There's a Latin phrase for it, which I can't think of right now. The rule exception principle, that is, a party who invokes a rule has the burden of proving the elements of that rule. A party who invokes an exception to the rule has the burden of proving the exception to the rule. And under that approach, claimant is invoking the rule that you must deliver goods that are conforming. It has to prove the elements of the rule. That is, that the goods were non-conforming in this case. That would seem to be the obvious way to approach that. There are some questions, though. Consider this discussion from the analysis of the problem for the use of arbitrators. Some teams may also try to approach the issue via different allocation of the burden of proof, i.e. considering respondent to be required to prove the conformity of the goods in light of the particular circumstances of the case. Such an approach would require a detailed argument of why the burden of proof is borne by respondent in the present case, as opposed to usual claimant would have to bear it. Factors which may play a role in this regard are proof proximity and respondent's contribution to the inability to determine the origin of the steel used. Proof proximity, what is that? Well, there is a rule commonly found in civil law procedures and jurisdictions, certainly in German law, which suggests that where the party who doesn't bear the burden has clearly superior access to the evidence concerning the allegation of breach, will reverse the burden of proof and put it on the party who would not normally bear it. In German, that's called Beweisnähe, Beweissnahe, I think. Beweisnähe, or proof proximity. And the question is, no. Is that, first of all, does that apply under the CISG? It's a lot of civil domestic laws. But does it apply under the CISG? And if it does, are the requirements for it to be met here, for it to be applied here, met? I mean, after all, the problem is not that respondent has superior access to the proof. That might be the case if it hadn't messed up its records. There isn't any proof of whether defective steel was used. So yeah, that's an interesting avenue to pursue too. I think there are probably other ways of framing the issue besides burden of proof. I've heard other people talk about this. By the way, to go back to the burden of the proof proximity deal, I will mention that I'm always a contrarian, and I have written an article saying that is, in fact, an illustration of the reason why burden of proof should not be governed by the CISG, and that it's not found in the CISG at any rate. It may apply in other ways, but it's not found by the CISG. At any rate, I think there are other ways of framing the issue concerning the uncertainty of breach here, ways other than through burden of proof issues. Now we think about Articles 71 and 72, which deal with prospective non-performance or repudiation of contract, that kind of thing, the threat of a future breach. Well, those provisions always talk about, and I think Article 72 is the one that might be easiest to talk about. It says, if prior to the date for the performance of the contract, it is clear that one of the parties will commit a fundamental breach of contract, the other party may declare the contract avoided. Now notice the future tense, will commit a breach. It's designed for a situation where a breach has not yet occurred, but there is a threat that it will occur in the future. Right? So it doesn't exactly apply to our situation. Here, the breach has or has not already occurred, and it's just a question of figuring out, getting to know about it. But perhaps the principles found, particularly in Article 72, might be another way to approach this as a general matter. Something to think about. Particularly given how the breach issue is framed in the analysis for arbitrators, where it says it is recognized, it is recognized that in special circumstances, the mere suspicion of a defective is based on facts, not facts, but facts, already constitutes in itself a nonconformity of the goods. Beyond the facts which justify the suspicion, the possible consequences of a nonconformity are important. And then there's a cite to the Kroll, Mistellis, Paralis Viscasillas commentary. So that was obviously something they had in mind. The analysis for arbitrators has in mind is the mere possibility or threat that premature corrosion and cavitation would occur in itself a breach. If this approach is accepted, of course, claimant must still prove the obligation concerning which there is sufficient suspicion of breach. You still have to prove that obligation, but that's not that is not the hardest part. It would certainly make it easier for claimant to prove breach, because I think claimant has an argument based on present facts that there is suspicion, reasonable suspicion, concerning the goods. So that is a different approach. It's a different approach to the question of breach, which has the effect of easing the burden of proof problems for a claimant. Let's now talk about the second substantive issue, which is, in case there was a breach of contract, is claimant entitled to request the delivery of replacement turbines, or, as the analysis of the problem for the arbitrators states, whether the special circumstances of the case justify a request for replacement of the turbines, even before that nonconformity has been determined with certainty. And this obviously triggers or invokes Article 46.2 of the CISG, which requires a fundamental breach by the seller, before a buyer has the right to demand substitute goods. But if there has been a substitute goods, and if the buyer if there has been a fundamental breach in form of a non-conforming goods, and the buyer has given the seller proper notice of that it wants a substitute, buyer has a right under Article 46.2 to recover to substitute goods from the seller. Of course, as we'll talk about in a moment, this provision of the CISG, like just as basically every other provision, all the ones we're interested in, can be eliminated by the parties. We talked about that in connection with Article 22.2 of the contract. It's also true that it is possible to eliminate Article 46.2 by contract. Now, putting aside for the moment whether the parties have eliminated the possibility of the buyer recovering substitute goods for non-conforming goods, Article 46.2 requires a fundamental breach, which is defined in Article 25 as a breach that, quote, results in such detriment to the other party as to, and here's the quite important word, substantially deprive him of what he's entitled to expect under the contract. So if there's a breach that hurts the buyer only a little bit, that does not substantially but only in a minor fashion deprives the buyer of what is entitled to expect, well, that would not be a fundamental breach. It would still be a breach, and there still would be some remedies available, but substitute goods would not be available, and avoidance of contract would not be available, but other remedies would be available in that case. But Article 25 also provides that detriments that the breaching party or a reasonable person in the breaching party's position would not have foreseen to result from its breach do not count towards the calculation of whether the breach has become fundamental. Although Article 25 does not specify exactly when you determine whether something is foreseeable or not. Contrast that with Article 74, which also requires foreseeability but specifies when you determine foreseeability. And I will say this, if you look at the case law, the courts have been courts and also there have been some arbitration decisions on this have been rather demanding in just how serious the consequences must be for a breach to be fundamental. On the other hand, consequences if there is excessive cavitation in this case, they're pretty big too. So note that Article 20 of the contract, specifically Article 22D, defines fundamental breach as not requiring a substantial deprivation of the aggrieved party's expectations. Should have underlined substantial there. It just requires any breach is going to be a fundamental breach subject to certain limitations, I suppose. This definition, however, is in a clause entitled termination for cause. See also the contract, Article 21, termination for cause. The question is, does it apply to Article 46.2, which does not involve termination or, to use the CISG term, avoidance of the contract, or rather specific enforcement of the contract. In fact, if you avoid the contract, you disqualify yourself from demanding substitute goods. It is a remedy available only if the contract has not been avoided. And the definition of fundamental breach, which is required for avoidance of contract, is found in the provision of the contract that is entitled termination for cause. It seems to be specifically addressed to that. Does it apply to this other remedy, which also requires a fundamental breach, but is not avoidance or termination of the contract? On the other hand, how different is requiring a seller to deliver substitute goods from terminating a contract and replacing those goods with damages for the extra amounts that the buyer has to pay? Substitute goods is it's linked in some fashion, or not linked, but kind of parallel, I suppose, in some fashion to avoidance of contract. I might point you to Articles 82 and 83, and once you delve into it a little bit, even Article 86, for ways in which there is some parallelism between Article 46.2 and avoidance of contract, which may make it easier to argue that Article 20 does eliminate, that Article 20 relaxes the requirement of a substantial deprivation as is permitted under Article 7 of the CISG. Even if there must be proof of a substantial deprivation for a fundamental breach, does Article 19.2 of the contract, which limits damages that the seller owes for downtime of the turbines to no more than $5 million US, does it suggest an allocation of risk to the buyer that limits the availability of remedies whose cost to seller would exceed that amount? Is that true in this case? So something to think about with Article 19.2. Now, of course, the claimant has not been able to establish a breach at all. There certainly can be no fundamental breach. Fundamental breach is a subset of breaches. The first thing you need is a breach, and then it must be a breach that substantially, rather than just a little bit, deprives the aggrieved party of what is entitled to expect. So you must have to establish the breach first in order to have a fundamental breach. And this brings up a couple of other questions. Is the $40,000 US per day penalty that buyer must pay Greenacre for downtime of the plant a foreseeable consequence of seller's alleged breach of contract? Remember that provision was added to the contract between the claimant and Greenacre after a while. How does the possibility of repair by the seller if there's a problem with the turbines, that's a remedy that seller has offered in this case, impact the determination of whether there is a substantial deprivation to buyer? If there is a repair, if it can be repaired, does that affect whether there's a fundamental breach? In this case, I would say. If repair can resolve the problem at less than substantial expense to the seller, is the breach not fundamental? excuse me, it should be, at less than substantial expense. Is the breach not fundamental? That should be, if repair can resolve the problem at less than substantial expense to the aggrieved party, which in this case is the buyer, is the breach not fundamental. Note the differing possibilities concerning the relative costs of repair versus replacement that are found in Appendix 1 to Procedural Order Number 2. Well, that is a little going over of the substantive issues in this case. As I say, I hope at least, even if I haven't broken new ground for you, it has at least been reassuring that you're on the right tack. And if you differ from me, it may very well be because you've got the right tack. Good luck in the moot, and I hope to see you soon.